Great news, another PD request granted. Motion to reopen granted, case is dismissed, client is free from removal proceedings or from being deported. Let's talk about it. My name is Bijoux Ngwanda. I'm an immigration lawyer based here in DC. However, I do have clients across the country and around the world because we are dealing with complex U.S. immigration law cases. If you're new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing, and please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like, and don't forget to comment below. Also follow me on all platforms. Links are in the description box below. Let's get right into it. This is a client, this is a unit, a family, the principal with the wife and the child. 3 people find themselves in removal proceedings without the notice to appear, without the order of deportation. However, they are in removal proceedings. Much complicated than you thought. So let's talk about it. This client came to the United States with a visitor visa with his family, and he was apprehended at the port of entry with his family and questioned. You know how they question you when you have a visitor visa. You have to respond accordingly, because if you don't respond accordingly, you find yourself in removal proceedings. That's what happened to this client. They questioned him and his family at the port of entry. Unfortunately for them, they did not know how to answer properly, and I'm going to talk about those questions at the end of this video. Please stick until the end so you will learn something about this video. Then they found themselves pretty much questioned, and with the order of supervision directly was given to them. So a referral notice, order of supervision, passports confiscated. They couldn't do anything. So they referred them to another office, ICE office, field office. But when they went there, the office was closed. They gave them a date, but unfortunately that date was an off day. So they went there, the office was closed, and previous lawyer applied for asylum with USCIS instead of following up to know what's going on, because once the ICE has given you the immigration referral letter and they confiscate your passport, it means you are under their supervision, and basically with an order of supervision, you are under their supervision. USCIS does not have jurisdiction, but unfortunately, I don't know what's happened with this previous attorney. They went ahead and applied for asylum with USCIS, and of course, because USCIS does not have jurisdiction, asylum gets denied. So when asylum gets denied for lack of jurisdiction, what are you gonna do? You're stuck in the limbo because you're looking in the board, in the immigration court system. Your name is not there because DHS failed to issue the notice to appear. But you can't do anything. You're stuck. And this thing happened to a lot of, this is what happened, that's what I meant to say. And this situation happened to a lot of people. I had another client who I talked to her previously. She told me the same story. I advised her to do the same thing we did for those clients, but I don't know if she's trying to decide whether or not to do it, but it happened a lot. So you're stuck. You can't do anything with USCIS. You cannot go to court because technically you are under ICE supervision, but the judge hasn't received your case yet for you to be able to, do something with the court, file your asylum with the court. Then you're just stuck there without a work permit, without anything. But because their country got designated for TPS, then they received TPS and work permit. But still, they can't do anything with USCIS in terms of if you are eligible to adjust status, or if you have a valid asylum claim, because those TPS are temporary status. So they came to me. I advised them that we're gonna file a PD request to dismiss the case and cancel the order of supervision, because technically once ICE tells you to show up, you don't show up, you are pretty much under supervision, because the day you will show up, probably they might arrest you, really. So we are going to dismiss the case using this Dolly memo, and try to work with ICE in terms of dismissing the case. But it was complicated because they can't find them in the system, but USCIS cannot give them anything either in terms of their asylum application got denied for lack of jurisdiction. So I had to work closely with ICE. Say hi to my friends in Miami, OPLA in Miami, very good job. So we had to work with them closely to find a way to place them before a judge so that we can be able to join a motion to dismiss. In other words, get their case reopened before an immigration court and file a motion to dismiss so that they can exercise prosecutorial discretion in terms of dismissing the case, and we can get the judge to sign that order. So that's what we did, because we agreed to do that. So I was confident that they're gonna do it because they previously agreed to do it. So we reopened their case in terms of the ICE issue a new notice to appear so that they can place them before an immigration judge, and then ICE was able to file a motion, a joint motion, to dismiss the case, and the case got dismissed. 3 people in removal proceedings, and now they are free. They can still file a asylum if they have a valid asylum claim. They can still file it with USCIS, and under those circumstances, they meet the exception, the 1-year deadline. The 1-year deadline rule exception. They do meet that deadline. Why? Because of exceptional circumstances beyond their control. So ICE was supposed to issue a notice to appear. They failed to issue it. USCIS lacked jurisdiction. They were stuck in the middle. They got temporary protected status to get the work permit. So they meet that exceptional circumstances exception in terms of if they still want to file for asylum with USCIS. Very complicated. You need counsel if you find yourself in this type of situation, because what's going to happen is, what was going to happen was in terms of removal, right? Because they were still under ICE supervision order and they were still under ICE jurisdiction. If it's time to remove you, they're going to remove you regardless of the order of removal, but at least you can fight. But the thing is, you are still under their supervision, okay? So in other words, they never passed the credible fear interview in order for them to be released and be referred to immigration court. That was really complicated. Again, you need counsel. I cannot explain all the details in one video, but what I'm trying to say here is that when you find yourself in removal proceedings, whether it is formal or informal, or in terms of being under ICE jurisdiction without being issued a notice to appear, you are still technically in removal, regardless of the order of removal being granted or not, because you can't do anything with USCIS in terms of adjusting status. You can't do anything with the court because the name does not appear in court. So you are stuck with ICE and ICE alone. You still have to deal with them regardless of your situation. So we had to deal with them, and they agreed to dismiss the case, and the judge entered the motion to dismiss in terms of signing that order of dismissal. So this is a great news. Now they can either file for asylum with USCIS because they meet the 1-year deadline exception, or once it's time to adjust status, maybe through children, when they become 21, when they turn 21, they can still adjust status with USCIS because they are free. That's what you need, freedom, okay? Freedom, 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 freedom. That's what you need. Especially now that we don't know what's going to happen this November with this Donald Trump attempt assassination. We don't know what's going to happen in November, who's going to become the president. What I know for now is that the Dolly memo is still current, is still valid. If you have to dismiss your case, if you have to administratively close your case, if you have to reopen your case, this is the time to do it. This is the time to put yourself in a better position in terms of legal documentation. Okay? And I wanted to talk a little bit again about B2/B1 visa, visitor visa for pleasure. When you get the type of visa, remember at the airport, they're going to ask you, why are you coming here? Well, you have to tell them exactly why you're coming here, right? If you came for a visit, you have to say, I came here for a visit. I'm going to stay with such and such at such and such hotel. And later on, if you find yourself that you have a valid claim for asylum, then you can apply for asylum. But when you tell the CBP officer or the immigration officer at the port of entry that, well, I have a B1, but I'm coming here to apply for asylum, of course, they will place you in removal directly, because that's not the purpose of B1 visa. B1 visa, it's basically you come here with the intent to return because you have ties back home, okay? Strong ties back home. That's the reason they're giving somebody a B1 visitor visa, because they're coming for a visit, and eventually after the visit, they will return home. But if you cannot properly indicate that to the officer at the port of entry, my friend, you'll find yourself in removal proceedings. That's a big mistake to avoid. If you need a consultation with me, you know what to do. You can schedule it by using the consultation link in the description box below. We're here to help, and this is the time, this is the moment. Dolly memo still valid. We're getting cases reopened, we're getting cases dismissed. People can adjust status. You need counsel, find one, okay? And again, if somebody asks how long the procedure is going to take, this was OPLA Miami. It took at least 4 months because we started back in March 25th, I believe, of March. We got a response yesterday. You make the math, okay? 4 months. Until next time, bye-bye.